any psychedelic.
Folks, good afternoon. We spent a few days together once again on Drew Psychedelic, and I'm here on behalf of Adrian Loya. Being a part of what we did the last few days, you saw the pains we take in the impalement process. The theory behind that obviously is we want to seek you heard the judge use the impartial jurors. We likewise would like to believe that any preconceived bias or prejudice are essentially left at the courthouse steps. But we don't ask any jurors ever to set aside their common sense. Like Mr. Glennie, his honor, told you about keeping the open mind, I will likewise do the same thing. But I will ask you throughout the trial to still utilize your common sense and exercise that gained through life's experiences. Now, it's a challenging case. We're going to be applying the same principles of law and so forth as one would in a trespassing case or a capital case of this nature. But it is still challenging. And as we all know, utilizing common sense, you know the judge will tell you eventually that the Commonwealth, and you've all heard this, bears that burden of proving the case. That proving the case beyond a reasonable doubt. And I'll just submit to you early because we're not arguing now, we're just hopefully helping you. But it is a significant burden. And you heard somewhat in the impalement process that it isn't only proving beyond a reasonable doubt that that fellow did these terrible, tragic acts. It's not only that, but they also must prove beyond a reasonable doubt that at the time of misconduct, that he, as a result of mental disease or defect, did not appreciate the wrongfulness of his conduct, or that he could not conform his conduct to the requirements of law. I'll submit to you, some people use the expressions, who done it? Though this isn't the case, you're going to see an abundance of evidence, a great majority of which came from that fellow, my client, as he wrote a 265-page document about this plan, as he wrote letters to Lisa, some 23 pages before this event. You're going to hear that some of this plan, or this planned mission, could have gone as long as 16 months, the planning stages, that it was meticulously planned, meticulously detailed in each and every nature of it. Listen for that. Not only that, what he left in the paperwork, but when speaking with the police officers on 2 different occasions for hours. And you'll have the opportunity to hear that. And I'd ask you to pay particular attention, not only to the acts that occurred on his birthday, somewhat unusual, February the 5th, 2015, his 31st birthday, but the specific detail in the 265 pages, in the detailing it to the police, because I'm going to suggest to you that's all going to wind in to his disease of defect. That's not the legal label. It ultimately will be for you, but how do we go there? Now, keep in mind, as the judge has instructed you, the defendant doesn't have to do anything. Why is that? As the judge told you, he is presumed innocent. But I think the evidence is going to show you and lead you down a particular path. And we have witnesses, and I anticipate you'll hear from witnesses in this case. And some use the expression expert witness. That's really where you become the judges. It will be for you to determine whether or not you accept or exclude. They're not given any grace because they're termed this, or they have a particular profession that could help give credence to their opinions. But you'll hear from I anticipate you'll hear from a Dr. Daniel. Let me step back. Experts, as one utilizing common sense could assume, they base their opinion on their database, or the accumulation of all information they can utilize to draw their conclusions. Well, you'll hear from Dr. Daniel, you'll hear everything he utilized to form his opinion. Not only were the police reports and 265-page documents and police report, speaking to collateral family, speaking to the Coast Guard in their investigation, speaking to the lawyers perhaps. He spent some 43 hours, the evidence will show you, with Mr. Loya. Some 43 hours. And he's going to suggest to you that he suffers from a significant mental disease or defect that both deprived him of the ability to conform his conduct to the requirements of law, and we go with that, what's called the McCool standard, appreciate wrongfulness, conform conduct. He's going to suggest to you, and that standard, ladies and gentlemen, is given to us in the alternative. So it's not and, it's appreciate wrongfulness or conform conduct to the requirements of law. Dr. Daniel, after spending all that time, you have the ability to praise him like us. You'll also hear from, and I'd submit to you, Dr. Daniel has a significant amount of experience, but you'll also hear from a Dr. Martin Kelly, who has a long history in testifying and so forth. You may hear such evidence that he has testified in some 300 to 400 cases. That he was originally hired. The court eventually asked him to speak to Mr. Loya, and he spent better than 9 hours with Mr. Loya. And pursuant to his training and his experience, he's a psychiatrist. He said, somewhat of a different label, where Dr. Daniel gives some type of delusional label, but it's a significant mental disease or defect. Dr. Martin Kelly suggests that it's on the autism spectrum. In fact, perhaps a high-functioning Asperger's. And because of that, and likewise, he suffered from a delusional base on that particular day. We're focusing on that day, February 5th, because it's at the time the conduct is committed, that he could not, Dr. Kelly could not conform to the requirements of law because he was in a delusion. In fact, it was in his mind, Dr. Kelly, I believe the evidence will show, it was a good against evil scenario. You're going to hear what was occurring in that particular day. That's why I said it's a challenge. This case is going to be a challenge. It's not the whodunit, but one has to look seriously at this testimony about what was going on. What was he doing in the planning stages? What caused him, what motivated him to do all this? And what was it as a result of? You're going to hear from there's a Dr. Holtzman, I believe, who works for the state, not wholly convinced of a mental disease or defect that would give or deprive somebody of the ability to conform their conduct. But what we'll also look to, and the evidence may show you that Dr. Holtzman didn't have that database I talked about, police reports. I don't think he had the ability to see Dr. Kelly and Dr. Daniel's reports. So one might suggest his foundation was not sound enough. Eventually hired years after this, and I would just submit to you at this time an opening statement. The most important time is the event sometime after 2 a.m. on February the 5th. In fact, the first call came into 911 at 2:11. Mr. Loya was taken into custody at 2:48. So there's roughly 36 minutes that's involved here that we're going to be looking at and ask you to keep an eye on. But you're eventually going to hear, I believe the evidence is going to show you, you're going to hear from a Dr. Ida Shine, who was eventually hired to give an opinion. And she gave an opinion. Once again, I'd ask you to look at what type of database does she have. She had a period of better than 8 months to go and visit and see Mr. Loya. One would hope to assist her in her evaluation of him. She never took that opportunity. But in light of that, she'll suggest to you he could conform, or he doesn't meet the standard. Why are you going to say that? I'd ask you to keep an open mind. The judge will tell you. That's ultimately up to you. Those folks, even if they're labeled the experts, it's going to be up to you, ladies and gentlemen, to make that determination. And she never, Dr. Ardishai never availed herself of that. Again, the whodunit aspect, keep an eye on where it came from. vast majority of Mr. Loya, because it's part of that delusional base we're starting with. And I'll eventually ask you to look, when you deliberate, look at all of that evidence to see that first aspect of that burden that Mr. Glennie has to carry from start to finish. You know, we can probably get over that first hurdle, but the second, at the time, and that's why it's such a challenge, at the time that he could conform himself, that he appreciate the wrongfulness, and I would submit to you at this stage that he could not. And after that challenge, one will submit that the Commonwealth could not get over that burden of proving the case beyond a reasonable doubt. Thank you.
Thank you, counsel. Sure.